This is Bloomberg Law with June Grasso from Bloomberg Radio.
The Supreme Court stripped the Securities and Exchange Commission of a major tool in fighting securities fraud in a decision that could also have far-reaching effects on other regulatory agencies. In a 6-3 vote down ideological lines, the justices ruled today that people accused of fraud by the SEC have the constitutional right to a jury trial in federal court, and that the agency's use of in-house proceedings violates the Constitution. During the oral arguments, Justice Brett Kavanaugh expressed concerns about the agency's use of in-house tribunals.
That seems problematic to say the government can deprive you of your property, your money, substantial sums, in a tribunal that is at least perceived as not being impartial.
The ruling could ripple across the government, potentially affecting other agencies like the FTC, the EPA, and the Agriculture Department. Joining me is Anthony Sabino, a professor in the Department of Law at the Peter J. Tobin College of Business at St. John's University. This was one of the cases we've been waiting for, Anthony. Tell us why it's important.
Well, the most important thing about this case, June, and where it will resonate is this. It's a very important preservation of the right to jury trial for all Americans. And that's why this case will have repercussions beyond the esoteric field of securities litigation, securities enforcement. Congress, back in the aftermath of the Great Recession, gave the Securities and Exchange Commission expanded powers to bring enforcement actions and to seek civil penalties against malefactors on Wall Street. Okay, and again, a laudable goal to be sure and necessary then as is now. However, what Congress forgot was the fact that when you accuse someone of fraud, they're entitled to a jury trial under the Seventh Amendment. The Congress had, in its wisdom, directed that such actions be brought or could be brought by the SEC before their in-house, and I emphasize in-house, administrative law judges. And obviously the SEC favors that forum because these are the ALJs who work for the Commission. And I'm not casting aspersions upon their neutrality or their abilities, but the bottom line is they are an in-house adjudicative body. What the court said today, and again, a very eloquent, very erudite opinion by Chief Justice Roberts, is that, no, hold on a second, okay? These folks are entitled to a jury trial. Why? Because securities fraud is a subspecies of fraud, generally speaking, generic fraud, and most especially in the fact that it is a subspecies of common law fraud. And common law fraud is something where you have always had, since before there was in America, an entitlement to a trial by a jury of your peers. And in Congress, in trying to redirect this away from a jury trial, violated the Constitution. And again, you see what's really a wonderful discussion, and hence its historical value and its precedential value, in the Chief Justice talking about how the right to a jury trial was taken away from us, stripped away from us by King George III. It was one of the precipitating factors in the American Revolution. That's why Jefferson discussed it in the Declaration of Independence. That's why it's the Seventh Amendment to the Bill of Rights. So it's very much embedded in the fabric of American liberty. Now, taking that and looking at securities fraud, again, as a subspecies of fraud, securities fraud in this country since the 33 and 34 Acts were promulgated in those years under FDR's New Deal, those laws have always borrowed liberally from common law traditions. So once again, securities fraud is simply a branch of common law fraud. And as in fact the Chief Justice points out, and he uses that pithy observation that the Court has said before, when Congress transplants something from the common law to modern statutes, it takes the old soil with it. And that's exactly what happened here. In creating the securities fraud provision, basically Congress said, okay, let's take common law fraud and all of its elements, and now let's simply couch that in terms of when you commit fraud in a securities transaction. But once again, it's a transplant, and the old soil, as the Chief pointed out today, goes with it. And for that reason, if you're going to try someone in any other kind of fraud, June, if you're going to accuse someone in any state or federal court of fraud, you have to prove the traditional elements to the satisfaction of a jury of that defendant's peers. So, too, is the exact same here, not to, forgive me, a bureaucrat who was an ALJ for the SEC.
Well, what was the SEC's position here for its use of in-house tribunals?
The SEC, in defense of its right to bring folks before one of their in-house ALJs and not before a jury, basically said, well, no, wait, this is something different here. This is a penalty created newly out of whole cloth by Congress, and it really is in the realm of public rights. Well, what the heck are public rights? Public rights are rights or remedies that have been created statutorily by Congress. And the court has long recognized that, well, if Congress gives you something in that realm, then it's not from the common law, it's something new. So you know what? We can allow this to be adjudicated by an in-house ALJ, someone or somebody other than a jury. Well, the Supreme Court said, no, that doesn't wash. And it referred to one of my more favorite cases from the bankruptcy realm called Grand Financiera that said, okay, hold on a second. You have to examine the right, the remedy that's involved. And if it truly is a public right, then yeah, you probably don't have a jury trial right. But if it's not, if it's based upon the common law, they're entitled to a jury trial. And Grand Fin, the question was, if you accuse someone in a bankruptcy case of fraudulently, emphasis on fraudulently, conveying property away from a debtor in order to deprive creditors of payments, the bankruptcy code is well known for adjusting the relationship between debtors and creditors, and a lot of it is statutory and rights given to you, public rights given by Congress, But however, some points of bankruptcy law, like we saw in Grand Fin, say, no, this is just transplanting the old soil of fraudulent conveyance under the common law, so guess what, jury trial. Again, same thing here. Relying upon Grand Fin for its analysis, the chief said, nope, fraud is fraud, and you get a jury, and that's the way it is.
So you wholly agree with the reasoning in the Chief's majority opinion?
Absolutely. And I also agree with Justice Gorsuch's concurrence, which is quite good because he also talks about the historical backgrounds here, the right to a jury trial, etc. And he makes a number of points here in that regard that, and again, he has a beautiful turn of phrase here where he talks about how the Constitution builds high walls and clear distinctions to safeguard individual liberty. And again, the jury trial is one of those. But also what Justice Gorsuch points out, and thank you, June, because this was going to be my next point. Again, there's going to be a lot of hand-wringing and no doubt Sturm und Drang about, this is going to cripple the SEC's enforcement efforts. Well, I'm sorry, that's a lot of nonsense. And basically, just don't believe me on it. Look at the very end of Justice Gorsuch's concurrence where he says the SEC has lots of enforcement tools. All right, all we're saying here is when you sue for civil penalties, then you have to go to a jury. For other remedies, the SEC will probably still be able to go before an ALJ. And in fact, in that realm, for example, there are remedies that don't require a jury trial. One of them is restitution, where you return money to defrauded investors, stockholders, what have you. Another one is disgorgement of legal profits. And in recent years, there was the Liu opinion by Justice Sotomayor that recognized that these are equitable remedies. And, June, as we well know, legal remedies, legal causes of action, you have to have a jury. That's the Seventh Amendment. Equitable remedies, such as we see in the bankruptcy code sometimes, as we see sometimes under securities laws, you don't need a jury. It's equitable. So the SEC can today, and they shall in the future, bring that before an administrative law judge in-house and continue the same way they have in the past. So bottom line on that particular point, for those who say this is going to put a dent in SEC enforcement and this is going to be giving license to the bad guys, my simple answer is no, you're wrong. The SEC is going to continue to chug along. The major difference is, and again, it burdens them slightly, but rightly so and for good cause, they're going to have to now plead their case before a judge and a jury in a federal district court.
This case was 6-3 down ideological lines. Why was this liberals versus conservatives? I
really don't think of it that way. As you rightly said, I cannot disagree that you see the so-called liberal wing of the court, Sotomayor, Jackson, and Kagan, dissenting here. That is their view about public rights and congressional power, and it's a little bit overexpansive. Indeed, in what I've seen from Justice Sotomayor's dissent here, is she's talking about basically the court is depriving the Article II branch, the executive branch, in the form of the SEC, their rightful power to enforce the law and to adjudicate it internally. And I appreciate that argument, but I think it's ill-considered, and I disagree respectfully as follows. The majority is right, and with all respect, the minority is wrong, because what the majority is saying is, look, what we're doing is this. We're making sure that the executive branch embodied in this administrative agency, the SEC, does not transgress the Constitution, does not overstep its bounds, and deprive Americans of a jury trial. It's not the self-aggrandizement of the Article III courts by saying, oh, now you have to come here, I have to give you a jury trial. No, it's a recognition of the liberty of the American people and anyone so accused of one of these heinous crimes that, hey, you're accusing me? Well, guess what? I have a jury trial right and the right not to be tried by some administrative person within the executive branch, the Article II branch. So I really think that's the point of contention there. It's a different point of view, but again, I say with respect, it's the other way around. It's not depriving the SEC of power. It is making sure that the Article III branch, the federal courts, do what they constitutionally are bound to do, supposed to do, which is oversee jury trial rights. But, June, most of all, it's not just about separation of powers and checks and balances. It's about the power of the American people against the government. And it is if you or I or anybody else is accused of, hey, you swindled somebody in a stock deal. Oh, you think I'm a crook. Oh, you think I swindled somebody. That's called fraud. Is it part of that sub-branch of securities fraud? Yeah. Guess what? Okay, if you accuse me of swindling you in a land transaction, selling you my car, okay, I get a jury trial. It's the same thing here, all right? It's not about just the tension between the branches of government. It's about the tension between the people and government and preserving people's rights to a jury trial. And that's why, to me, this case is, of course, it's a securities law case, no denying that. But you're going to see this discussion resonate and be repeated again when we talk about preserving the sanctity, if you will, of the jury trial in all sorts of other proceedings. And that's why this will have ramifications for administrative proceedings, enforcement actions in other branches in the federal system as well, be it antitrust with the FTC, be it consumer products with one of the other agencies. So this thing has traction, that's for sure.
Coming up next, does this decision indicate how the court will rule in one of the most high-stakes cases of the term? I'm June Grasso, and you're listening to Bloomberg. In a 6-3 vote down ideological lines, the Supreme Court ruled that people accused of fraud by the SEC have the constitutional right to a jury trial in federal court. The case is among several this term likely to have broad implications for federal regulators, as conservatives and business interests are urging the court to constrict the power of the so-called administrative state. And during oral arguments in this case, Chief Justice John Roberts expressed his concerns about the growing power of federal regulators.
The extent of the impact of government agencies on daily life today is enormously more significant than it was 50 years ago.
The court's 6 conservatives have already reined in federal agency power, including in a decision last year that sharply limited the EPA's ability to police water pollution in wetlands. I've been talking to Anthony Sabino, a professor in the Department of Law at the Peter J. Tobin College of Business at St. John's University. During the oral arguments, the Justice Department said more than 24 agencies now impose penalties through administrative proceedings. And then only some of those have the option of going to federal court instead?
Right. And you see, that's one of the keys, okay? And I understand the government's position as much as I disagree with it. And the court has said, well, sorry, but you're wrong. Here's part of the evolution of Jarchese. Now the battle is going to shift. We're going to see increased emphasis and therefore increased litigation over the precise contours of what are remedies. The Chief Justice made a point, a very powerful point, that the expanded enforcement powers of the Securities and Exchange Commission, which now must be subjected to a jury trial, not to a SEC in-house ALJ, those are civil penalties that are designed to be, and I quote them, punitive in nature, to punish and to deter. And the court pointed out that the SEC, if it wins, it doesn't have to give the money back to investors. So that's a purely punitive measure. You have to give someone a jury trial right when you seek that kind of civil penalty. Once again, as I mentioned earlier, the SEC has the power to seek other compensation, if you will. This is what Justice Gorsuch mentions at the very end of his concurrence in the form of disgorgement. Oh, you made some money, give it back. Okay, restitution. You defrauded John Smith, give the money back, etc. So there's another branch of remedies that are not penal in nature, are not punitive. They are equitable. And the Supreme Court, when they're faced with that, I have no doubt, and again, the groundwork was already laid by Sotomayor a couple of years ago in the Liu case, is that, that can be brought before an administrative law judge. That can be in-house at the SEC, and you do not have a right to a jury trial. So once again, this is going to evolve. Jarchese is going to evolve. It's going to branch off, and I fully expect 3 years from now, you and I are going to be having a conversation about another Supreme Court landmark in 2027 that defines the contours between civil penalties, where there is a mandatory jury trial right, and an equitable remedy such as disgorgement or restitution, where equitable, so therefore there's no jury.
I'm going to have to get a calendar that goes farther than my current one.
You and I both.
So one of the big cases we're waiting for involves the Chevron doctrine and whether that 40-year-old doctrine will survive or not. It basically means a deference to agencies when regulations are ambiguous. Do you think the decision in this SEC case indicates how the court will rule in that case?
To me, it does. Once again, and I hate to, paint with a broad brush with respect to ideologies, the nine justice, they're all equal up there. But once again, if I engage in a little political punditry here, we see the division of the justices, the 6-3 here today. Will the court move along those same lines in Loper-Bright, which we hope to get tomorrow, possibly? And again, I perceive your point, and I agree completely. One of the aspects of Jarchese is this. It's a demonstration that the Constitution must be honored, and sometimes that means the necessity of curtailing the power of administrative agencies, whichever agency that may be, whether it's the SEC here or the Federal Fish and Wildlife Fisheries Service in Loper-Bright. Okay, so to me, this is in many respects a precursor, a flare going up, if you will, and I think there are hints of what might happen tomorrow, the next couple of days, with respect to Loper-Bright when it comes down. And again, the whole point is this, and this is why I see the linkage, if you will, the connection. Jarchese is about honoring the Constitution, its text, and the constitutional plan, and saying Americans have a right to a jury trial when they're accused of certain wrongdoing. Loper-Bright, in terms of whatever it does with Chevron and whatever way it goes, should be about honoring the Constitution, saying what are the boundaries upon administrative agencies, unelected officials of administrative agencies, with regard to the American people. It's almost the 4th of July. I'm not trying to wrap myself in the flag, but I must say this, all right? This is about American liberty. This is about preserving liberty. This is about freedom. So those are the more transcendental issues that I see here. And bottom line is, again, Jarchese, all right, I think this is a pretty good sign as to what might very well transpire with Loper-Bright in the next day or two.
A lot of legal experts are warning that getting rid of the Chevron doctrine could throw long-standing regulations into doubt. It could crimp agency power over things like workplace conditions, drug safety, climate change, etc. And there would be a deluge of lawsuits challenging agencies and regulations.
I firmly do not believe that. And if I may, I'm going to use a word that I've heard Mr. Biden use quite a lot in recent times, and that's this: malarkey. I think that's a lot of malarkey, okay? Jarchese is not going to curtail the SEC's enforcement efforts. The basic change is one of tactics, whereby you don't go in front of an in-house, ostensibly friendly, if I may say so, ALJ, who works in the same building with you, is paid by the SEC the same way, etc. You're going to go to an Article III judge appointed for life, but more importantly is you're going to see 12 ordinary American people in that jury box. So the vector, the direction of these cases will change somewhat in terms of tactically, but still, the burden is going to be the same, June. When you accuse someone of securities fraud, you have to prove those 6 elements, which again differ only slightly from the 5 traditional elements of common law fraud. So you still have to make your case, the evidence, burden of persuasion, etc. With respect to the issues that are being addressed in Loper-Bright is this: agencies are not going to be curtailed if the Chevron deference standard is modified or in fact eradicated in whole or part. All it's saying is it restores a balance. The problem that not just I, but Justice Scalia had during his lifetime, that Justice Thomas has now with Chevron, is that it basically created an imbalance. It gave an unfair advantage to the agencies to say, okay, we're an agency, we're the experts, experts have gotten us in recent years, if I may say so. We're the experts, so you have to listen to us. And it diminished the power of judges to do their job, which is to judge. So now if Chevron is curtailed, modified, what have you, it restores balance. At this point in time, in an administrative case, in the case with an agency, the agency has a clear advantage, and it's a zero-sum game. Advantage to the agency means disadvantage to the public. If you modify Chevron deference, now you restore balance. It's even, as we like to say in sports, it's a level playing field. Agency comes in, argues the case, citizen comes in, she argues her case, it's all even, there's a balance.
Let's talk about the practical implications of the Jarkissi case, because it's expensive to go to trial in federal court. So would a defendant have a choice of federal court or an in-house proceeding?
You are correct, and I'll give you the perfect analog for that. Antitrust trials, as we know, are incredibly complex. They involve literally days, if not weeks, of what's incredibly, forgive me, boring testimony from economists and other experts. And again, case in point, United States versus IBM, that boondoggle which ended in no resolution whatsoever. But basically the parties decided the defendant, IBM, said, no jury trial, because no jury is going to sit there for years to listen to all this boring evidence. So parties can make a decision and say, look, all right, this case would not be understood by the average layperson. This case is far too arcane and complex. And also, you know what? Let's just go see the ALJ and let her decide it. And again, let me be clear. I've spoken about the need to limit the power of ALJs. That's one of the issues which Jarkissi bypassed, unfortunately, because that's the one I addressed in my amicus brief, so I'm a little sad they left that one out. But I understand the reason. As you and I know, it's axiomatic that the court need only decide as much of a case as it needs to. So you say that Jarkissi has a right to a jury trial. He has to be in front of an Article III judge. We don't need to decide whether there's a power of removal of an ALJ. But again, that'll be the next case. I'm looking forward to writing that amicus already. We'll see that in a couple of years. But the bottom line is, the key differential, June, is this. It's a choice. If a defendant says, you know what, I'll go with the ALJ. And once again, I've talked about the need to check and balance the power of administrative agencies, but I still respect ALJs. I still respect their expertise and the job they have to do. It's a tough job. It's a demanding job. But in the right situation, if a Mr. Jarkissi or someone like him in the days to come says, you know what, I don't want a jury trial, the jury's not going to understand this. It's too arcane. It's too complex. I'll go with the ALJ. That's fine. The important thing is there's a choice. There's a choice. And once again, when you look at the mosaic, if you will, all right, and I know there's going to be the hand-wringing and the gnashing of teeth. Oh, it's going to impact the agencies. It's going to handicap the agencies. It's going to make it too more expensive. Again, the answer from me is, my opinion is no. They're still going to have to bring their case. The difference is now persuade a jury of the defendant's peers as opposed to persuading the single person, the ALJ. So there will not be a sea change. There will not be a fundamental change here. SEC enforcement will go on. Enforcement of these other agencies will go on. Again, you're simply changing, you're shifting direction to persuading a jury as opposed to persuading an in-house ALJ.
Well, we'll find out perhaps as early as tomorrow whether the Chevron doctrine will survive. Thanks for being on the show, Anthony. That's Anthony Sabino, a professor in the Department of Law at the Peter J. Tobin College of Business at St. John's University. The Supreme Court has 6 more cases left before it adjourns for summer vacation. Those cases involve questions of presidential immunity, a criminal charge used against January 6th defendants, the constitutionality of Texas and Florida's social media laws, homelessness, and, of course, the Chevron doctrine. Coming up next on the Bloomberg Law Show, the Supreme Court allows emergency abortions in Idaho for now. This is Bloomberg. The Supreme Court confirmed today that it will allow abortions to take place in medical emergencies in Idaho for the time being, making official a decision that was inadvertently posted online yesterday. Over 3 dissents, the justices reinstated a federal trial court order that ensures hospitals in the state can perform emergency abortions to protect the health of the mother. The court had blocked that order in January and allowed Idaho to fully enforce its near-total ban for 5 months. The court dismissed the case as improvidently granted. The about-face is at least a temporary victory for abortion rights advocates. Doctors and hospital administrators say the state's law was keeping them from treating women with serious health risks, even if they had no chance to deliver a healthy baby. Joining me is an expert in reproductive health care rights, Mary Ziegler, a professor at UC Davis Law School. So, Mary, this was 3-3-3, and the court as a whole didn't explain its decision. So what does this stand for?
Well, I mean, I think that we have the best clues from the opinion offered by Justice Barrett that the three kind of swing conservative justices believed that the terms of the litigation had changed in what they saw as consequential ways since the court agreed to hear the case. And I think the three were interested in this spending clause theory that Idaho had raised, but believed that it had never been heard by the lower court. So I think it stands for the proposition that maybe those justices are willing to side with Idaho. Maybe they're also interested in some kind of what they would view as a compromise ruling, but that in either case they weren't ready to reach a final conclusion before the election.
The opinion by the three liberals talked about what's happening to women in Idaho who need abortions and didn't get them, sort of echoing what Justice Kagan said during the oral arguments. How bad has it been in Idaho?
Yeah, I mean, from what I've gathered, there's evidence that there have been significant harms in Idaho, that patients have been, airlifted to other states in a handful of circumstances. We know that there have been knock-on effects in terms of people not choosing Idaho for their medical residencies, that having further effects on access to care for pregnant patients across the state. I think, obviously, in terms of scholarly documentation of that, we're just at the beginning. But there is data, I think, including data cited by Justice Jackson in her opinion, to the effect that even allowing the law to go into effect when it did has had real-world effects.
And so it was only the three liberals who said that EMTALA requires hospitals to provide abortions, that Idaho's law prohibits, that, Idaho's law is preempted by the federal law?
Yeah, I mean, I think Justice Jackson clearly wanted to reach that conclusion. The other two liberals were willing to go along with the idea that it was okay to defer a decision, essentially that the petition had been improvidently granted. It's probably fair to assume that that was, a compromise on the part of those liberal justices, but Justice Kagan did take it upon herself to respond to some of the conservative justices' points on preemption, and we can certainly gather from that she doesn't think that the preemption arguments that Idaho had raised were very good.
And tell us about the dissent by Alito.
Well, there was a lot there. I mean, Justice Alito wrote about the spending clause argument. He also spent a lot of time on the fact that EMTALA uses the language unborn child, which Alito suggested created express protection for the unborn child, as he put it, and would by definition mean no emergency access to abortion for patients. That's obviously an interesting and significant conclusion because the statute just used the word unborn child, didn't say anything more about unborn children than that. So Alito's conclusion seems to be if a statute uses language like that, it suggests a belief that an unborn child is an equal rights-holding person or patient, at least for statutory purposes. So that's a pretty revealing reading of the statute. Again, even though that isn't going to be the legal upshot, at least for now.
Well, Alito has suggested in oral arguments and elsewhere this concept of fetal personhood before, hasn't he?
Yeah, I mean, he's used personhood-adjacent language in Dobbs, so we know that he's been at least open to this kind of question. He hasn't, of course, addressed constitutional questions of personhood in the sense of the conclusion that fetuses have 14th Amendment rights, clearly in any of these cases, but the way he's approaching the question certainly suggests that he may be open to that kind of argument.
He also chided the court. He said, the court has simply lost the will to decide the easy but emotional and highly politicized question that the case presents. And then Ketanji Brown Jackson on the other side, the court is not willing to make a decision here. It's punting. And she pointed out that even though this means that there is no clarity in the law, no clarity for doctors.
Right. I mean, you do see that coming from both Jackson and the conservatives, essentially, that the court took this case and should have had the courage to definitively resolve it. Of course, neither of those wings of the court have the power to make that call, though. It's a reminder of kind of where the power in the court lies at the moment.
The justices took 2 abortion cases this term, and in neither did they reach the merits. In the mifepristone abortion pill case, they went off on procedural grounds. So, I mean, why take the cases, especially this case where it was an unusual procedure?
Well, I think that it's hard to know why the court took the case. I imagine that at least at some point, the conservative justices thought they had the votes to side with Idaho, and then realized that they didn't, potentially because the oral argument in the case was such a disaster for the state of Idaho. I think, obviously, Chief Justice Roberts has been concerned with the court's reputation and the damage to it in the years since Dobbs, and may have argued that the time was not right, given the procedural problems and complexities of both cases, and he may have found a more receptive audience in Justices Barrett and Kavanaugh than he had previously, not only that because this is an election year, but also because there were procedural and strategic mistakes made by the conservative attorneys in both of these cases.
So explain what happens now, what this decision actually does.
Well, in the short term, this decision has the effect of reinstating an injunction that a district judge put in place in Idaho permitting emergency access. That litigation will continue through the Ninth Circuit Court of Appeals. The decision does nothing to disturb a ruling by the Fifth Circuit Court of Appeals upholding an injunction against the Biden administration and allowing Texas's law to be enforced as written with its very narrow abortion exceptions. And it doesn't do anything to change the situation on the ground in other states with very narrow exceptions, although there is some EMTALA-related litigation potentially proceeding in some other states like Oklahoma. So essentially all of that will continue as if none of this ever happened. The Supreme Court may come back into the picture. Then again, it may not, because if polls are correct and Donald Trump wins the 2024 presidential election, a Trump administration would almost certainly withdraw this EMTALA guidance and not really try to intervene on behalf of patients facing life-threatening emergencies.
And I believe Justice Jackson indicated that Fifth Circuit case will likely be coming up to the court.
Yeah, no, I think that will be going up to the court, and I think the case from the Ninth Circuit may too, again, unless Biden loses the 2024 election and Trump stops interpreting EMTALA in this way and the case becomes moot.
Do you surmise that in these cases, the justices or some of the justices are thinking about the fact that there's an election coming up and not wanting to rock the boat too much, as Alito says?
I think that's a possibility. I think that there are, again, I think this is a scenario where there were plenty of off-ramps for a court that didn't want to decide these questions in an election year, given the fact that Idaho did what it did at oral argument, didn't raise these questions about the spending clause until later, given that there were standing problems in Alliance for Hippocratic Medicine. But I think that there were almost certainly political concerns that dovetailed with those legal and political and strategic questions.
So as far as looking back at this term, what conclusions can we make about abortions?
Well, I think we can conclude, we know that there are some divides within the court about abortion, but they concern primarily how much further to the right to move the court and how much federal intervention to limit voters' ability to decide for themselves which abortion rights protections they want, how much in that direction the court is going to head. We know that that's on the table. We don't know which way the court ultimately is going to go because, again, so many of these substantive questions were deferred.
This case and the subject of abortion are sure to be subjects at the debate this evening between Biden and Trump. And speaking of voting, do you know how many states will have abortion on the ballot in November?
So there, I think, are 4 states that have confirmed ballot initiatives. There are 3 states where they have submitted signatures to get on the ballot, where likely there would be a potential upshot there. And then there are 3 where there are further signatures being gathered. So I think a lot of those are likely to end up on the ballot, but the status of several is still TBD. So Colorado, Florida, Maryland, and South Dakota are all guaranteed to be on the ballot. And there are several others that are possibilities, including Arizona, Arkansas, Missouri, Montana, Nebraska, Nevada, and Pennsylvania.
We'll be following those closely. Thanks so much, Mary. That's Professor Mary Ziegler of UC Davis Law School. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcast. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.